I'm Sarah Miller. I'm the Vice President of Communications for the Small Business Association of Michigan. And we're happy that you've joined us today for this webinar with the American Arbitration Association. This webinar is being recorded. We will share the recording with you after the fact, and of course, it'll be available in our webinar archives on the website within the next couple of days as well. A quick reminder that you can find all of our upcoming events at spam.org/events, and any of our other webinars are all in our Media Hub under the Resources tab. So with that, I'm pleased to turn it over to Katherine with the American Arbitration Association. She's going to give us a little bit of intro to our special guest today. And so Katherine, thanks for joining us. I'll turn it over to you.
Thank you so much, Sarah, and good morning, everyone. My name is Katherine Gloede. I'm the Regional Vice President for the American Arbitration Association, also known as the AAA. A few weeks ago on October 17th, AAA did a similar recorded webinar, but that one focused on arbitrations. That presentation is archived should you want to reference it, and Sarah will provide a link to that in the chat. But for this webinar, I want to focus on mediations, a slightly different concept in dispute resolution. And to help me do that, we do have a special guest. It is one of our esteemed arbitrators and mediators, Tom Cranmer. So welcome, Tom. Thank you so much for joining us today. And can you please tell the audience a little bit more about you?
Sure, Katherine, thank you. And Sarah, thanks to you as well for having me as a guest. Yes, just by way of background, when I went to law school, now many decades ago, I figured out pretty quickly that I wanted to be in the courtroom. I didn't want to be at my desk drafting wills and estates, although that's important. And so when I got out of law school, I tried to find a venue or an avenue that would get me into court pretty frequently. And I did. I started as an assistant prosecuting attorney in Oakland County, Michigan. And I was there for about 2.5 years. And I spent a lot of time in the courtroom and kind of honing, if you will, my litigation skills. And then after about 2.5 years, I went down to the city of Detroit, and I was a federal prosecutor, something called an assistant United States attorney. And I was there for about 4.5 years. And from there, then I went out into private practice with a firm that did kind of a broad range of commercial and business types of law. I was there for about 20 years or so. And then more recently, in 2004, about 20 years ago, I joined my current firm, which is Miller Canfield. And Miller Canfield is a large Michigan firm with offices throughout the state and actually in other parts of the country and other parts of the world as well. And we consider ourselves to be a full service firm. We do a variety of different things, almost anything that's law related. And once again, I continue to do litigation. And my practice currently is probably divided up into 3 broad categories. The first is really what we're going to talk about today is what we call ADR, or alternative dispute resolution, which is both mediation and arbitration. And then another third involves business or commercial litigation. And then the last third is I still do, as a result of my work as a prosecutor, some criminal defense work.
Thank you so much, Tom. What a beautiful background you have. And for the purpose of this presentation, we picked someone that screams Michigan. And as you can see, we've achieved that with Tom. Tom has a long history working in Michigan for Michigan businesses and Michigan citizens. So thank you for that. Tom, for those of us that don't know, what is mediation in a nutshell?
Well, in a nutshell, it's something that's both kind of old and new. Old in the sense that the idea or concept of mediation has really been around for a long period of time. And I think many of the people in our audience have been involved as mediators, if you will, although they may not quite fully recognize it at the time. If there's a dispute, say, between maybe employees at your business, you often have to mediate that dispute. You have to find a way to bring a resolution to maybe a couple of employees who are at odds with each other. As parents, we oftentimes do some mediation work, if you will, between our children if they're having a disagreement or what have you. So it's old in that sense. It's been around for a while. As to, I'll call it the litigation world, it's somewhat newer. When I started as a a trial lawyer and a lawsuit was filed, if the case was going to be settled, it would usually be done between the lawyers themselves. They would talk about a settlement or a resolution, obviously in consultation with their clients, but they were doing kind of the heavy lifting. But over time, and particularly I would say, Katherine, over the past 15 years or so, the idea of employing a neutral outside party, a third party who can come in and kind of take a fresh look at the dispute and try to find a way to bring each side together in a way that will resolve the case efficiently, effectively, and in a way that hopefully allows people to move on has become much more prevalent. So that's really what mediation is all about, and that's the mediator's role, is to try and take a fresh look at a dispute. The mediator doesn't really have the so-called dog in the fight. The hope is that the mediator can bring some clarity to the situation and help the parties find a way to resolve their dispute.
Thank you. That's a very nice synopsis.
Mhm.
You mentioned some of them, but what are some of the additional benefits of mediation over sort of traditional litigation approach?
Well, I think for me, it starts with the idea that if you look statistically at the number of cases that go to trial, it's really a very, very small percentage. Unlike what we see on television or in the movies and what have you, our focus is kind of on a trial. The honest reality is that in today's world, when a civil lawsuit is filed, more than 99%, and think about that number, more than 99% of the cases actually get settled. Now, sometimes cases are dismissed along the way, but the much more likely outcome as opposed to a trial is that the case is going to be settled. So if that's the case, if the statistical odds are such that it's an overwhelming likelihood that your case is going to be settled, doesn't it make some sense to try to do that sooner as opposed to later? Because that way you can hopefully save some cost and expense, some mental energy, if you will. And so that's certainly one of the real big factors, I think, in terms of why it's important and helpful. But beyond that, it also is a tremendous, or can be a tremendous cost-saving device. And the way I like to think about it is that if you think about lawsuits that are filed, whether it's a $50 million case, that is $50 million is at stake, or if it's a $50,000 case, or maybe even a $10,000 case, what you have to do to start from A to Z, meaning what you have to do to prepare that particular case for trial, is essentially the same. You have to go through the same process of what we call discovery and various motions that are filed in the court and what have you. But what you might spend in terms of a $50 million case oftentimes doesn't make any sense at all to spend in a $10,000 or a $50,000 case. And so the idea of mediation is helpful in terms of a cost effectiveness. And I'll say the last big thing, at least for me, and I think for most people who are involved in the process, is that it gives parties the ability to control and shape the outcome. Again, I've been in the courtroom a lot. I've tried a lot of cases, and I will tell you that I have great faith in the system, whether it's a decision decided by a judge or a jury. But both judges and juries are not always predictable. There is not always a guaranteed outcome. In a mediation, though, you have the ability to shape the outcome and control how the matter is resolved. Now, to be honest, it doesn't mean that you're always going to decide the case, or I should say, settle a case in a way that you completely hope for. That's often not the case, and I think that makes some sense. In any negotiation, you don't always get everything that you want, but it does bring certainty to the situation. And I think it also, particularly for small business people and business owners, allows them to get on with really what they should be doing, which is focusing on their business. Litigation can be a tremendous distraction in terms of not only time, but also energy and expense, as I mentioned. So that's the other thing. It allows you to control the outcome. Oops. Catherine, you might have muted.
Yeah.
Ah, there you go.
Yes, I love how you phrase that because, Tom, what you're talking about is finality. And when you reach an agreement with a party via a settlement using a mediator, that gives finality. Like you said, parties can move on, they can focus on their business, versus even if you get that win in that courthouse and you've got that jury verdict in your hand or whatever form that's in, there's always that risk of appeal. And so, when it comes to finality, coming to your own resolution is one very good way to ensure some finality in a situation over traditional litigation methods. So thank you for that. Is a very big pro, especially for business owners who are focused on other things like growing their businesses. So thank you for that. Now, every mediation is a little different. Every mediator is a little different. What is your unique approach to mediations, Tom?
Well, I don't know that it's all that unique, but I certainly agree with you, Catherine, that every mediator, I think, has his or her own style. And what I found in the context of mediation is that it's really important that you be a good listener. You need to make certain that each side has the opportunity to kind of state their position and be heard. And I've found over time, as I've grown more experience, that that really is a critical element of mediation, allowing people to be heard. And sometimes it's simply a matter of just that, letting someone vent and someone being assured that someone is listening, someone is hearing what they have to say. In litigation, that's not really how the system works. Essentially, the two sides are at kind of loggerheads, if you will, and each side is trying to, in my words now, kind of shout down the other side and prove that he or she or their side is the correct side. That's not really the approach that you want to take in mediation. What you want to do is give the parties the opportunity, again, to state their position, but to try to focus them on getting to a resolution. And so at the beginning of my mediations, I meet with both sides and their lawyers and try to explain to them that our goal here today is to kind of put down the swords and look towards a way to find a resolution, something that can be a win-win situation for both sides. And when it comes to small businesses, sometimes that can mean figuring out a way to not only resolve the dispute at hand, but also figure out a way that the two sides can work together on a going forward basis. I mean, if you could do that, you definitely have kind of a win-win situation. Now, again, not every case allows that, but at a minimum, what you want to do is give the parties the opportunity to work together in a collaborative, cooperative way to find a resolution to their dispute. Because, again, at the end of the day, the case is going to get resolved. It's going to get resolved one way or the other, most likely by settlement, but even if it goes to trial, there's going to be some finality. And why not try to find a way that is going to be as helpful to both sides as possible? Again, not a complete victory for either side. That's not going to happen realistically, but an outcome or a result that both sides can live with and kind of move forward with. And so I try to set that table, set that tone right at the beginning. I try to set expectations about where we're going and how we're going to get there and the best way to get there. And that's to be open-minded and collaborative in terms of trying to reach a resolution.
Thank you. That was very well put, Tom. And as you know, our audience today is comprised of small businesses in Michigan. So how can mediation apply best for this population, would you say?
Well, I would say that for our audience, I'd say mediation, from my perspective, has a particular appeal because more often than not, I think our audience is involved in what I consider to be smaller cases. Yeah, it doesn't mean that they're not important. They're very important, but just the amount in controversy or at stake usually is not extremely large. And because of that, I think you want to find a way, you find the best way to not only resolve the case, but to do it in an effective and cost-efficient manner. And that's where I think mediation really shines. And particularly if you can do it at a very early part of the case, if a case gets filed, that's even better, right? If you wait to the very end, which sometimes happens in mediations, after all the, we call it the discovery, the depositions, the questioning going back and forth between the lawyers, the motions and what have you, is finished, and then you try to mediate the case, it can be very successful. And at times it's helpful to do that because by then you've really kind of staked out and fleshed out the issue. But sometimes, again, that maybe is a little bit too late in the process, and it kind of diminishes what the advantages are that I just articulated about it being cost effective. So again, as I've grown more experienced in this field, I think trying to get people in early, to mediate early, I think can be very effective. And again, particularly for our audience in terms of I'll call it marshaling their resources and using them towards something that is more productive, growing your business and continuing your business, as opposed to respectfully paying lawyers to go into bat.
I love how you put that as well, and you bring up an interesting point. So in terms of early mediation, I know that at our last webinar, we talked a little bit about arbitration. In order to trigger arbitration, you would build a clause into your contract. And actually, AAA has a lovely portion of its website called Clause Builder that actually helps parties draft those clauses. And as part of those clauses, you can actually, and parties, have the option to actually build in a mediation requirement, right? So they'll say, you know, before this case can be arbitrated with American Arbitration Association, the parties must first mediate the matter, you know, things like that. And the exact language to use can be incorporated via that clause builder. And you can make that, you know, as specific as you'd like, but that is one great way to ensure that if you have a dispute, let's say with a vendor, you're a small business, you use a vendor, and you are a fan of mediation, Tom has convinced you, you can actually build that into your contract as a requirement that the parties must first mediate the matter. And oftentimes, like Tom says, that can knock that out very quickly and cost effectively. So we've been seeing that more and more, and parties have been requesting that more and more. So thank you, Tom, for mentioning the timeframes of that. So Tom,
Catherine,
yes.
I was going to say, let me build on that for just a moment. Oftentimes we'll see in contracts that are drafted by we'll call it the business lawyers, they will include in their contracts that if there's a dispute about the contract or in terms of the contract, that indeed the matter will be resolved not in court, but through the arbitration process. And very, very often, those clauses indicate that AAA will be kind of the method, if you will, the vendor, the resource to handle that arbitration. And just as Katherine was saying, more recently now, we see that as part of the standard language there, that there's a reference to mediation, and as kind of a precursor, as a first step to seeing if the matter can't be resolved in that fashion. And I have to say, I've been kind of a proud AAA arbitrator for more than 25 years now, and I will say unabashedly that AAA is really the gold standard when it comes to these kinds of issues, the alternative dispute resolution mechanism, whether it's either arbitration or mediation or a combination of both. The AAA does a wonderful job in terms of seeing that the disputes are handled in a very professional manner. They have a very robust organizational system that makes sure that the mediators and arbitrators don't have any conflicts, and they have case managers for each and every file so that they help keep the matter on track. And I think from a cost efficiency standpoint, again, they do a very good job of providing a wonderful service in a cost efficient manner. So just my own little personal plug for the AAA. They are terrific, and they're a pleasure to work with as both a mediator and an arbitrator. And when I have my other hat on as a lawyer representing a client and we have a dispute and it's in arbitration, I'm always trying to make sure that AAA is the one that handles it, because I know it will be handled the right way.
Thank you for those kind words, Tom. And just to add on to that, because in our last webinar, we talked a little bit about arbitrations and the clauses and some of the perks of arbitration, but those same things apply for mediations. And the one that comes to mind is confidentiality, right? So any mediation, typically where it takes place, mediators like Tom will say, sometimes they'll have parties actually sign an agreement so everyone's on the same page that what happens in that mediation session stays confidential, right? And mediators have to maintain that confidentiality. But even bigger picture, whenever, let's say you're a small business in Michigan and you're contracting with a vendor, when you put that clause in there, saying that maybe there's a precursor of mediation required, and then if it ends up in arbitration through AAA, right? What you get by doing that is confidentiality. So you have to remember the alternative is the public court system. Everything that's filed is a public record. And we actually have trolls out there all over the country. We think of this like with celebrities, filing the Jen and Ben divorce in California. Those things are caught because they're publicly filed documents, and there are trolls out there. They could be looking for IP secrets. They could be looking for celebrity gossip. It could be journalists, news reporters, but those are publicly filed documents. When you file with the AAA, that is not a publicly filed document, right? So you don't have those same kind of issues with trolls or, and even sometimes parties, put in the complaints like, think of, disparaging things about you and your business, maybe on purpose, maybe not, but it never even hits that public sphere. We have a full closed system, and that's not something open to the public to examine our pleadings or anything along those lines. So matters handled with AAA we are a confidential forum, and traditionally mediations fall within that same closed sphere. So that's a real perk to the system. And so that's nice too, because there may be things that you as a party might feel comfortable telling the mediator, but you wouldn't feel comfortable telling the other side or telling others. And so confidentiality is an important component of mediation. So thank you so much. Now, Tom, like bigger picture, we were just talking a little bit about dispute resolution. Where does mediation fit into the larger picture? Because I know sometimes, at any point in a case, like you said, Tom, the attorneys can say, hey, let's talk this out. But sometimes people look at that like a sign of weakness. I know when I was a litigator, I was such a believer in dispute resolution, but I always felt that if I was the first one to say, hey, would you want to mediate this? It was perceived as a sign of weakness. So, how does that fit into things, into the larger picture?
Yeah, that's a great question, Catherine. And I think you're right. I think the idea of suggesting something other than a full-out war where each side has the boxing gloves on and is trying to knock out the other side in the past has been viewed as a sign of weakness. But I think fortunately that has really changed. And that it's changed, I think, because it's become such an important part of the dispute resolution process. Kind of not keeping yourself boxed into one particular way of resolving a dispute and trying to think outside the box. And so mediation has become very, very popular in that sense. And I think, fortunately, it no longer carries that same stigma. Frankly, I think you would agree it never should have. But the idea of it being a sign of weakness now, I think, has gone away, and it's really something that both sides, I think about, at least the lawyers do, pretty regularly and routinely. So to have it suggested is something that's fairly common. And again, I just see the idea of mediation increasing pretty much every year that I practice. When I started out practicing, as I mentioned before, the idea of having an individual mediate was really pretty much unheard of, with the exception of, to a certain extent, the judges themselves, as they would handle their docket, would oftentimes try to mediate their own cases, try to bring the parties together. But gradually over time, this has become something that, again, as we've talked about, is much more prevalent. And people are out there essentially doing this on a full-time basis. And again, having somebody take a fresh look at a case and kind of bring ideas that maybe the parties haven't fully focused on, or perhaps are embarrassed to suggest, for maybe the reason that you indicated, Catherine, it's showing a sign of weakness. Having a mediator do that can really be very, very helpful and effective.
Thank you, Tom. And we're in our last 5 minutes. So if anyone does have any questions, please feel free. You can contact Sarah. You can put in the comments or raise your hand, but we do want to open it up to questions. But while we're waiting for those to come in, Tom, you mentioned that judges would informally, in your experience, try to mediate matters, but that's not always a good thing to have the same person who will ultimately decide the issues to be the same person to mediate. And, traditionally, there's a little bit of separation of powers there. So the person who mediates your matter oftentimes is not the person who's the final person. Why might that be an important, benefit to have that separation there?
Yes, you're absolutely right about that. And I think in the past, when it was just judges trying to mediate their own cases, and by the way, they still do that, I think judges always are a little bit queasy about that for the very reason that you identified. Well, boy, I don't know how much I can push each side because I'm ultimately going to have to hear this case, probably decide the case, make some rulings in the case. So I'm a little uncomfortable with that. But again, as you point out, in terms of, we'll call it the private world of mediation and arbitration, it's a good idea, I think, in almost every instance, to have someone who's a mediator not be the same person who ultimately is the arbitrator or the decider of the case. And the reason for that is that as the mediator, you want to have each side be very candid with you in terms of, I'll call it the goals they have in terms of trying to resolve the case, but also the strengths and weaknesses of their position. And I spend a lot of time with each side trying to build their confidence, to let them know that I'm there not to browbeat somebody into a particular settlement, but I need to know kind of the honest issues that are there in the case. And so if they're going to do that, if they're going to trust in me, they have to believe that if the case isn't settled, that somehow these kinds of things that they share with me aren't going to be used against them at a later point in time, nor should they. So the idea of having a separate person as a mediator who's distinct and separate from the individual who's the arbitrator if the case can't be resolved, I think makes a lot of practical sense, and really from kind of an ethical position too, I think it's important. Because again, I try to get the parties when I'm mediating to be very honest with me and tell me what their bottom line is and where they want to get to and what have you. And if they're going to share those confidences with me, they have to know that they're going to just be shared with me and not be used against them later on.
Thank you. That's so important. Thank you, Tom. I'm not seeing any questions coming in, so I think we can go ahead and wrap our webinar today, but that was wonderful. Tom, thank you so much. If folks want to get a hold of you, what is the best way for them to reach you?
Well, probably the best way and the easiest way is just to send me an email. And you can do that. My email address is just my last name. You see it, I think, on the screen, CRANMER at Miller Canfield, which is the name of my law firm.com. So it's just my last name, Cranmer at MillerCanfield.com. And again, if people have questions, I'd be happy to do my best to answer them.
Thank you so much, Tom. And there will be a blog post covering mediations that will be posted for everyone if there's any desire for some written materials in support of today's webinar. And please stay tuned, as there will be one more webinar on another dispute resolution topic coming down the pipeline. So thank you, everyone. Thank you, Tom. Everyone have a wonderful holiday, and we'll catch you next time. Thank you.
All right. Thanks so much, everyone.
Yes, thanks everyone. This was really helpful.